So what I'm going to talk about is neurodiversity in the workplace. Now, there's a big reason I'm talking about this, and it's because over, I would say, the last 5 years or so, there has been a major increase in the number of claims which I am seeing, which involve neurodiversity, primarily of claimants, with issues in the workplace. I'm looking around the room for a show of hands, because I bet you if I ask you the question I'm about to, there aren't many of you who don't put your hand up. How many of you have seen a case involving neurodiversity in the last sort of 5 years or so? And nearly everyone in the room. And I think that tells us something. And I think what it tells us is that for all there is a lot of lovely ACAS guidance out there about what employers should be doing and what they shouldn't be doing, employers seem not to have caught up with the fact that neurodiverse employees carry with them their own unique needs, and it requires a bit of unique consideration when you are dealing with a neurodiverse employee. And what I think I tend to see is there's this blanket, it must be like a mental health condition, for example, or it's not really a disability, is it, for somebody to be neurodiverse? And that leads to, as we know, problems. Now, I'm going to caveat this with, I'm not a medical expert, please don't rely upon me as one. What I'm going to try and do throughout this seminar, I'm going to try and give as best I can a little bit of practical guidance and a little bit of practical insight, really by two sources, or from two sources. One, ACAS is a wonderful source of information for issues relating to neurodiversity. And I'm not going to embarrass anyone, but I bet not many of you, because I hadn't really looked at it that much, have looked at the specific guidance on ACAS to do with managing employees with neurodiversity. And the second area, or the second source, is I'm going to try and give you some as best I can from my own experiences in dealing with multiple cases involving neurodiverse employees. And I think it's really important, obviously we all know that if you get it wrong, you could be on the wrong end of a disability discrimination claim. Your workforce morale is likely to suffer, productivity will go down, and it's also important for us as lawyers to understand a bit more about neurodiversity, not least because we need to be armed with information to properly advise our clients, whether we're acting for the employee or the employer, but we as lawyers also need to know what it means to be neurodiverse and how a neurodiverse employee may behave, so that anyone who's a lawyer, neurodiverse or neurotypical, can understand that and respond accordingly in something as basic as, for example, correspondence with the other side, or discussing and liaising with what on the face of it might seem a difficult employee or a difficult claimant, and learning how to deal with that and how to manage that, and also making our clients aware that this is what we might be faced with when we're dealing with a tribunal claim. Because in the tribunal, there have been, and I've put these figures in your handout, paragraph 7, and I'm going to just pick some examples of the statistics. Autism-related decisions nearly doubled from 2020 to 2025. Dyslexia cases rose by 78.4% in the same timescales. OCD-related decisions doubled from 4 to 8. Dyspraxia saw a 175% increase, so I confess that doesn't really sit with my experience. I don't know that I've yet seen a dyspraxia case, but I think we need to be aware of it. And then apparently Tourette syndrome remained consistently high. So what is neurodiversity? Neurodiversity is not, as it were, a mental health condition. That's one basic fundamental principle, which I think as lawyers we need to understand, and it's not always clear. It's ultimately a way of describing the differences in how people's brains works. And interestingly and importantly, neurotypical individuals will see neurodiverse behaviors as difficult, as they're being blunt, as they're being a little bit argumentative, whereas the individual in question doesn't see it that way at all. And I think that is one thing we all need to be very much alive to, as do employers. Probably more important, I would say, than what neurodiversity is what neurodiversity isn't. Because unless we know what it isn't, we're not going to avoid the stereotypes, and employers are not going to avoid the stereotypes that creep in. So someone who is neurodiverse does not mean they cannot function. I've dealt with cases, and they are, whether I'm for employer or employee, and there's almost an underlying feeling that someone who is neurodiverse has the inability to function, especially, lo and behold, when they manage to get a diagnosis. yet they've been the same employee throughout, and then all of a sudden they get a diagnosis, and yet somehow at that point they seem to no longer be capable of functioning in the eyes of the employer. It also doesn't mean that they're thick. People have this stereotype that anyone who is neurodiverse is unintelligent. Quite the opposite. Many individuals who have neurodiversity are sharp, bright, and extremely intelligent, extremely creative. They can have lots of advantages actually over a neurotypical individual, which employers might actually be able to use to their advantage if they were not so focused on the negatives rather than the positives. It's also laden with stereotypes. Things like ADHD, someone who's got ADHD can't sit still. They're incapable of, as it were, keeping focus on anything. They're lazy. No neurodiverse condition is the same. These are not new principles, but somehow employers seem to be struggling, I think, to grasp that this is the case when it comes to neurodiversity. I've dealt with some specific neurodiverse conditions, and I've picked 3, and I've picked ADHD, autism spectrum disorder, and primarily dyslexia. And I've set out some of the common features of those, as it were, neurodiverse conditions. And the reason I've done that is because my experience tends to see in the employment tribunal claims dealing with the 2 big ones that I see a lot are ADHD and autism spectrum disorder. So what does it mean to be ADHD? And again, this comes with a big fat caveat, no individual is the same. But just as a flavour, someone with ADHD might find it difficult to concentrate on tasks. They might struggle with time management and organisation. They might have trouble following instructions. They might have times of hyperfocus. And we'll see in a moment or towards the end when I speak about litigation how that might play out when you reach the litigation stage. They might be better at thinking creatively and have lots of energy. Now, this is something which I wasn't particularly familiar with, reacting differently to senses like sound and smell. I was aware of sound, but not necessarily smell. Getting anxious about social situations, that's one we're all probably familiar with. Difficulty interpreting social cues. Now, these are all pretty basic things, and they're so basic that we need to be alive to them, because I can quite see in my day-to-day practice when 2 managers or a manager's interacting with an employee, what the manager thinks is someone who's ignoring them or being difficult or not listening is a neurodiverse employee who's struggling to take the social cues, who's struggling in the conversation, and who's struggling to engage. And I don't think managers have really quite got a grasp of that yet in the world of employment. So I said I wasn't going to talk about a lot of law, and I'm not, but I am a little bit. It wouldn't be a legal seminar if I didn't talk a bit about the law. So the first question is the neurodiverse employee disabled? So the very first test they need to get across in order to establish most of their disability discrimination claims. And we're all familiar with Section 6. I am not going to go through Section 6. And the way I want to do this is refer you to a relatively recent authority in the AAT, the case of Stedman and Haven Leisure Limited. Now, what happened in the case of Stedman and Haven Leisure Limited was ultimately a claimant applied, in that case, for employment, and their employment was not successful. They make a claim, there's a preliminary hearing to determine whether or not the individual is, who in that case had a diagnosis of autism and ADHD, was a disabled employee for the purposes of the Act. Now, they had the usual impact statement, they had their GP records, and in that case, they had a report from a psychiatrist confirming a diagnosis of ADHD and autism. In that case, the tribunal said, no, you're not a disabled person at all material times, despite the content of your impact statement. They were a bit critical on some occasions that the individual had exaggerated or over-egged the pudding, so to speak, and didn't quite rely on that part of the evidence, but not in others. It goes up to the EAT, and the EAT judgment I would recommend you read, actually, if not simply because it's a really good summary and a good reminder to us all of the principles to be applied when we're dealing with the question of disability. But there are some really interesting comments in the world of neurodiversity, and I do want to look at those a little more closely. I've essentially cut and paste paragraphs 57 to 61 of the judgment. And it might be said that these comments are obiter, but I'm not one for normally going against what the EAT says, even if it's obiter. And I've not met many employment tribunal judges who are likely to go against the comments of the EET either. And there are really two things which I think come out of this, which are of real use, whether we're acting for claimants or respondents, in a case where neurodiversity is the disability relied upon. And it's the first point I've highlighted, where the judge in that case said, well, all judges should be familiar with the Equal Treatment Bench Book, and also with the principle that a diagnosis, in broad terms, reflects a clinical judgment that someone is significantly different from the norm as regards the area of functioning covered by the diagnosis. And so it's a really good tool, actually, which we might not have otherwise thought to use. But the second, and I think more interesting point, is in paragraph 60, where it says, where a tribunal has before it evidence of a clinical diagnosis of autism or ADHD, accordingly then, unless there is some reason to doubt the reliability of that clinical judgment, the tribunal must take that diagnosis into account, not just as evidence that someone has a condition or impairment, pausing there, the first step in the Section 6 test, but as evidence as to the impact of that impairment. The diagnosis means they have been judged by a clinician to have significant, i.e. clinically more than minor or trivial, difficulties with the areas of functioning covered by the diagnosis. And the reason I think this is actually quite important, because I've spent years in the tribunal, and there have been various cases over the years where perhaps an employer wants to get a medical report, and you have a judge saying to you, well, Mr. Crammond, why do you need a medical report? Is there a question over the fact they suffer an impairment? What else do you need it for? The rest is a matter for us. It's a matter for evidence, whether it's a substantial adverse effect on normal day-to-day activities and it's long-term. We don't need medical evidence for that. I think if that were the position you're faced with in relation to at least a neurodiverse claimant alleging they were disabled, I'd probably be waiving this authority in front of the employment tribunal, because I think this case says fairly and squarely the opposite. What it's saying to us is the diagnosis is good, not just for the question of is there an impairment, it's also good for whether or not there is a substantial adverse effect on someone's normal day-to-day activities. So I think that's a shift in thinking, certainly from many of the tribunals I've been in front of when this issue of medical evidence comes up. So I want to talk a bit about how we manage neurodiverse employees. And the first thing I want to talk about is, I'm not going to go through this in lots of detail because we all know the basic principles of the kind of claims that may be faced by employers under the Equality Act. And my view on this is the most likely claims to come out of an issue with a neurodiverse employee are your Section 15 claims, your failure to make reasonable adjustments, your 2021 claims, and probably harassment. There's some room for indirect disability discrimination, but my view tends to be, what does it add if you've got yourself a failure to make reasonable adjustments claim? And there is room for direct discrimination. I've given you a first instance decision in the case of Crawford against the Chief Constable of Cumbria Constabulary. Now, I would absolutely implore and ask all of you to read that decision, because it's a really good judgment setting out how each of these claims succeeded. But it's also a very good example and a good lesson to all, which is, if employers have a concern about someone's capability or whether they can do the job or whether they can perform the role in promotion, give them a try. Give it a trial as a functional assessment even, to work out whether or not they can or they can't do the role. Because if you don't, your employer may not then be able to satisfy the justification test because they may not have acted proportionately on a Section 15 or a Section 19 claim. There's lots of general things that an employer can do which ACAS recommends employers do. And I'm not going to go through them, but they talk about, in a broad sense, about raising awareness, doing training for managers. And one of the things they say is about having a neurodiversity policy. Now, again, I'm going to ask for a show of hands here. How many of us have seen employers who have a specific neurodiversity policy in their organization? Got one, two, maybe a handful, 6, 7? I've never seen one. I've never seen a section in an ordinary policy on neurodiversity, nor have I seen a separate policy which is related to neurodiversity. ACAS tells us employers probably should be having those sorts of things. But it's a good example of how I don't think employers have yet caught up. So the big area where issues can arise with neurodiverse employees tends to be about performance, conduct, and capability. And there are really two areas to this, I say, in terms of reasonable adjustments to be made, And it's about managing the performance and the conduct in the first place. But let's not forget the second strand, which is how do we make adjustments to the processes and procedures that are in existence when you're taking them through a capability process or a disciplinary hearing. I've tried to separate them out into adjustments that might assist with concentration, some that might assist with written communication, some that might assist in organisation skills, and so on and so forth. The reason I've set those out is really for two purposes. One, to give us all something that we can put in our top drawer and then pull out when we're asked to advise an employee or an employer and think, how might we start thinking outside the box here? Occupational health don't always get this right. Medical experts don't always get this right. It's one of those areas where occupational health and GPs may not actually be your best source of information as an employer in determining what kinds of adjustments are reasonable or sensible. There are specific organisations out there who can and will assist with determining what kinds of adjustments are necessary. And I would probably advise any employer to really start thinking about going to those specialist organisations for further guidance. And please don't just fall into the trap of, well, we've given you this, and this adjustment. What more do you want? Lots of employers think we did everything for you, but when there's one or two other things out there which you didn't do and would be very straightforward to do, you haven't fulfilled or satisfied your duty to make reasonable adjustments. And I challenge many employers to say, well, for example, talking through written information. I mean, how difficult is that for any employer? It's not. It's really straightforward. Giving someone a timetable in order to manage their workload, really straightforward, really simple, but can make the world of difference to a neurodiverse employee. We're not reinventing the wheel here. We're not asking for anything, out of the ordinary. We're asking for really small adjustments which can make a very big difference. And I think that's what I think employers really tend to miss. It's the classic, computer says no approach I find with many employers. There is a real need to think outside the box. And the question about in processes and procedures, and there is a lot of overlap here, and I accept that. But in terms of processes and procedures, some common ones, again, talking through the written correspondence. Setting out meeting records clearly and succinctly should be happening anyway, doesn't always happen, but it's more important for a neurodiverse employee. Allowing someone with knowledge of the employee's neurodivergence to attend formal meetings. For example, whether it's a support worker, a member of their family, someone in their medical team who you might think is going to put this person at ease, who's going to be able to understand, quite possibly, and I use this phrase widely, to interpret the reactions that you are seeing as a neurotypical manager faced with a neurodiverse employee. If you've got somebody who understands the person, they're going to be able to soften what might otherwise look like a blunt blow from the employee. They'll be able to explain to you in much better terms what that person's thinking. Modify your language and letters, have remote meetings rather than in person, and so on and so forth. So those are just some of my hints and tips and experience in dealing with neurodiversity cases. And as I said, no case or no two cases are the same.